Today's topic is stamp duty and registration. Often, I found is that whenever we are talking about the document, I feel there is a confusion about what is stamp duty and what is registration act. So, when a document may require registration, may not require registration. That doesn't mean it will not require a stamp duty. With that object, I have started this today's topic, which will I initially thought it will be over in one session, but it's going to we'll have to have two sessions. So I made it part one and part two. It's a new format I am taking this time is that first I will take question. The whole object is that when we are discussing the question, that is where you are going to learn more. So in that process, when we this is a new format, I have not seen anyone adopting it, but I felt that for our case it should be more relevant. With that object, I have kept this format. So what we'll do is that we'll first take the question. In the process, we are going to learn a lot. So I'm not going with a normal with the presentation which I do, but I will take a question in the process. We'll go through many of the provisions. So now let's start with the question which was put on the chat box. I will just open the chat box from my end. Just a minute. Okay. Lakshman, is he there? Lakshman? And see, I want your engagement in this webinar so that I understand one part whether you are understanding or not, or other parties are whether you are taking part or not. It is no point just you are hearing me and then going away. I want you to take active part in this webinar. So is Lakshman there? And I told specifically I will be taking those questions only which those who are attending the webinar. Unfortunately, it is not there because what happens is that if you want to ask something more question on that or some more clarification is required, then they can give it. That is the whole object. Anyhow, he is not there. But his question was that building conveyance is done in 90. Yeah, I will take. I'm just going through the those who are posted on this thing. Building conveyance done in 1970 is still stamp duty to be paid on every sale deed chain of document. That is a question. Basically, I think he's trying to ask me is that conveyance was done of a building in 1976. So that's what I guess. What is his mean is that, and whether it's required to pay the stamp duty on chain of document. See, whenever again coming to that, whenever any document is executed, if it attracts stamp duty, it attracts stamp duty and it has to be paid, and stamp duty has to be paid. Whether registration is required or not, it is totally a separate aspect. When we are talking about stamp duty, we are strictly talking about stamp duty. It has got nothing to do with registration. So if this document, which are chain of document, which is required to be stamp duty, which is required to be paid, it is required to be paid. But question which came few months ago, similar question arose in Bombay High Court. I think Justice Patel, let me just write down. I think Justice Patel said you can't force someone, a subsequent buyer, to pay the stamp duty of earlier transaction. And I will share those this thing. Rakesh, just remind me these things. That judgment will share in the separate group. And I'm very strict on this. Those who are attending the webinar only they are going to get this kind of judgment and many other things which I will be sharing. Okay. So basically, the transaction, if there are a chain of transaction, a stamp duty is required to be paid. But a person who doesn't pay, or a subsequent buyer you can't force subsequent buyer to pay the stamp duty. That is the judgment of our Bombay High Court. We'll be sharing it. Anand has asked a question. Flat registered in 1987, but due to some reason stamp duty has not been paid. Even original agreement is still with the registrar. What is the remedy? The remedy is, earlier the process, which I don't know how many of are there. The process was that you lodge a document for registration and it used to take years to get back the document, because that is before I started my practice, or maybe just I think around 90s. That the document used to go to Pune, then they used to make some copies, some separate process, and it used to take 3 to 4 years. That's what I am told. So that way your document might be gone. You can search it and you will get it with the receipt. When you get a receipt, with that receipt, you will have to make some struggle and you will have to get this document. Where there you will be having something from which you will understand where the document is. No, understand, just take it my word. In government department, document will not disappear. They will be somewhere which will have to trace it. That's all. So next question which Anand is asking is, conveyance deed, is it necessary that all flat pay the stamp duty? If not paid, what is the remedy? Yes. Stamp duty, which I guess Anand is here. Is
Yes.
Anand there? Yeah. Huh? Is Anand there?
Hello.
Ah,
Yes.
yeah. Okay. Okay. See, when we are talking about this, I guess you are talking in the respect of a conveyance of a society, building society by the owner or by way of deemed conveyance. When we are talking about deemed conveyance or a conveyance of a flat, of a property, what happens is that you get a set off for the stamp duty which is already paid by all flat purchase. Let me give an example. These are all hypothetical example. There are 100 flats in a society for which every person has paid, suppose for our discussion, 1 lakh rupee as the stamp duty. Subsequently, now when you are going for registration, the stamp duty which becomes applicable to that property, let's assume, is coming 1 crore 5 lakh rupees. So stamp duty, I'm talking strictly about stamp duty. I'm talking strictly about stamp duty. I'm not talking about LBT, which is applicable at certain places, which is 1%. So when we are talking about stamp duty, 1%. So let's suppose the stamp duty comes for the conveyance of that property is 1 crore 5 lakh rupees. In example which I gave, in that what happens? There are 100 flat and each flat owner has paid already a stamp duty of 1 lakh rupees at the time of getting into agreement for sale of the flat. So already you have paid 1 crore rupees as a stamp duty. Now balance amount which is remaining has to be paid is 5 lakh rupees. So what you are going to get? You are going to get a set off of that 1 crore rupees. So you will have to pay the balance 5 lakh rupees. And if it LBT or all those things are applicable, then that 1% certainly, whichever way, you will have to pay it. And along with that, registration charges of 30,000. I presume the maximum registration charges you will have to pay at the time of registration. Why those document or index 2 is requested by the department of the stamp is that to understand or know how much stamp duty is paid on that. Is it clear, Mr. Anand? Or any more query on that?
Yes. I just want to ask you, can you hear me?
Yeah, I can hear you.
I have not paid the stamp duty.
You are
Okay.
not paid the stamp duty.
Okay. Now, if I go for the original documents, what is the stamp duty they will be charging me? It's the
The
present
stamp duty.
rate or the old rate?
No, they will be charging you the old rate
Okay, okay. Yeah. Thank
plus
you.
this thing.
Mm. Yeah, thanks.
Yeah. Then the next question, which is by Vika. Recently, I have done a family arrangement agreement. My client got it verified with society. However, society say it needs to be registered by paying a stamp duty. My query is, what will be the stamp duty need? Stamp duties. What will be the stamp duty needs to pay in such an agreement, and is it compulsorily registered? Can we just notarize the family arrangement? I think I have put one this thing about family arrangement. If I not put, I will put this thing. What is a family arrangement? The Supreme Court and High Court also say does not require registration or the stamp duty. But what are those arrangements? We have to first see into that. What is those arrangement? If the arrangement is recording past transaction, understand this: recording past transaction, then it will not require stamp duty and registration. Suppose, take an example, you are doing a family arrangement, you are giving a nomenclature. Understand that. It's a nomenclature you are giving. Bear me why it will be significant, because family arrangement, it's a settlement or it's a deed of partition or deed of release. It will all depend on various factor, what you call it. We'll go through all those things. By family arrangement, suppose there is I just again hypothetical, I don't know, he has not given the, is there? Vika is there? Vik, is it Vikasha? Yeah. Mrs.
Yes,
Okay.
sir, I'm there.
Yeah, yeah, sorry.
No
Yeah.
problem.
See, just giving an example. If there are a four flat, and as per the family arrangement, each brother or sister or the family person is going to get a one flat each. The question will come when you are selling that flat. You say that by family arrangement you are transferred, or under family arrangement one person is going to get that flat. But a person who is selling that flat, what is the title deed for him? A family arrangement which is unregistered and unstamped, and no buyer is going to acquire or buy such kind of flat. So those Supreme Court says, but if you see those judgment, I will again put that it's basically is recording the past transaction. So therefore, if you are recording a present transaction by which you are assigning, someone is releasing it, right, that will, according to me, will require a registration and also attract a stamp duty. Yeah. Anything you want to ask, Vika? Vika, right?
Yes, please.
Yeah.
Sir, like in this case, there's only one property, one flat,
Hmm.
wherein there are three siblings. So it is only, owned by one elder brother,
Huh.
wherein he wants to, assign the rights and title to his sister and one more brother, younger brother. So that is the
Okay.
only family arrangement agreement all about. So
Eh,
do this agreement needs to be registered?
See, I told you, moment you are assigning something, you are doing it require registration. Otherwise, the person who has acquired it, who got it, can't make any third party, right? No one is going to acquire that flat from him. Can't that come into the gift tax? Sorry, gift. One can't that come into gift?
Here only they are just giving the assigning the title. They are not given the right to sell the flat to the sibling.
Understand this. If there
Okay,
is a transfer, there is a transfer. If there is no transfer, there are two things.
correct. Okay,
So either he is giving or is not giving. It's a digital.
We are giving the it's a transfer of rights. Yes.
It's a transfer. Moment you are saying there is a transfer, it will attract a stamp duty. It will also require a registration if you want to claim any right on basis of that document.
Okay, sir. Got it.
Yeah. So again, good that why I'm taking this way is that you understand with practical this thing with practical example what is the transfer, what is the how the stamp duty aspect will come into this. See, in this case, what is she telling is that she is telling there are three siblings, and elder son wants to give it to younger daughter or younger daughter and younger brother. So what you are doing, there are three things. One is that if only they, Vika, only the flat is in name of elder brother.
Yes, sir. Yes, sir.
Yeah. So now what is
We just
effectively doing is he is transferring his flat to his sister and brother.
no,
In
three
that
of them
case,
will
what
be equal rights to three of them. Even he will be the
equal right? Okay, okay. So what is doing is that okay, I understood. So what is basically is doing that I am not aware of what is the object of it. Basically, what he is doing is that he is assigning his two-third right
yes,
to brother and sister.
sister.
So
Correct.
again here, though you can give it nomenclature as a family arrangement, still it will attract a stamp duty.
Got it, sir.
We'll go to those provisions also. Family arrangement, Rakesh and Pallavi just remind me those sharing of those judgment. Okay. Now, gift deed, stamp duty on gift deed, release deed, inheritance released by joint owner. Okay. Now let's start. What is the stamp duty on the gift deed? So when we are talking about the stamp duty on the gift deed, we will have to see the what are the provisions and the schedule. Right. So before that, let's go back. When we are talking of a stamp duty, it is not a transaction which attracts a stamp duty. It's a document which attracts a stamp duty. So when we are talking about a gift deed or any transaction of this, we have to understand if whether it falls into certain categories. What Stamp Act says is that Stamp Act state about the schedule of the proper schedule which for which stamp duty is attracted. So let's now see the Stamp Act. Oh, I have not opened it. Okay. Yes, I will screen share. Are you able to see this screen, all of you? Put S in the chat
Yes, sir.
box. Yeah. Put S in
Yes.
the chat box. Yeah. See what it says. Subject to provision of these acts or unless exempted, the following instrument shall be chargeable with the duty amount indicated in the schedule as proper duty thereof respectively. That is to say, every instrument mentioned in Schedule 1 which has not been previously executed by person and executed in the state or from the date of commencement of this act. So what it talks is because of duty which a stamp which will have to be paid as per the schedule. Now, schedule is given at the end of the stamp duty, and what are the documents which are covered in that? It is given at the end of the schedule. Before that, before we go to the schedule, let's see some of the definition in the Stamp Act. See, Vika, right? See the definition of settlement. Means any non-testamented disposition in writing of movable and immovable property made in consideration of marriage for purpose of distributing property of the settler among his family for those whom he desired to provide or purpose of providing for some person dependent on it or XYZ. So they have defined what is a settlement, which you are talking. It's same thing. Settlement, if you see in the language of Stamp Act. Other thing when we are talking, when it will often come into our discussion is document. But if you are seeing it from a Stamp Act perspective, they always rightly tells everyone you will find an instrument. Never you will find there is a document mentioned. Instrument. So basically, instrument means nothing a document. So is it clear, everybody, for you that instrument means basically a document, right? If yes, put in a chat box yes. Okay, we'll start. See, they have given many definition. I already shared this document. See, instrument means, I just was telling, instrument, every document by which right liability is purported to be created, transferred, limited, extended, extinguished, so and so, but does not include bill of exchange, check, promissory note. So they are exempted certain things. Again, there is the instrument of gift, instrument of partition. I will suggest you go through it, because otherwise even 10 hours webinar will not give you anything. Whole object of this kind of webinar is to give you a thought process, invoke your thinking. That's what I want to do. If you are attending this webinar and forgetting everything, you are not going to know about the stamp duty. Even in the paid webinar, of course, in the paid webinar, we are going in more detail at length, and even stamp duty itself is taking around 3 to 4 sessions in that. So it's a different ball game over there. But here, what we are is a thought provoking. I'm just giving you something to think about, and then you can go on self exploration on this. Okay. See, one of the definition which here is of important for many of us is that one you will find is of conveyance. So what is conveyance? They have defined conveyance on sale, instrument, every final decree, order of civil court, etc. So they have defined what is called conveyance. Why it is defined here? Because you will find in the schedule, when we will go down right now, in the schedule, they are spoken about the conveyance on different aspect. Even when there is a merger or amalgamation of the two companies, it's a conveyance. The document by order, when it is passed under section 233 of the New Companies Act, it will attract stamp duty for that also. So these are the many definitions are given over here. What is instrument? What is a lot of definitions are there in that. Go through that definition. Executed, immovable property, all those things. You go through that definition. Lease, many definitions are given. For us, one thing is important is for our discussion right now is this market value of the property, which for our discussion will be important. Market value in relation to any property which is subject matter of an instrument means price which property would have fetched if sold in open market on the date of execution of the instrument, or the consideration stated in the instrument, whichever is higher. Yes, I will explain you what is a market value. What it says is that the amount which it is stated in the instrument, or the market, or if it is sold in an open market, what is the amount it will fetch. So suppose one person is selling a flat. I'm just giving a hypothetical example. Selling a flat, suppose for 1 crore rupees. And market value. Let's take two different scenario. Market value of that flat is 1 crore 20 lakh rupees. So now question comes, how the market value is defined. How we will calculate the market value. When we are talking about this transaction, I gave 1 crore is the sale agreement, which is the agreed transaction rate, and 1 crore 20 lakh is a market value. So on will what amount you will have to pay the stamp duty? Can you put it in the chat box? On what amount the stamp duty will be calculated? Stamp duty is always percentage of the market value. So put in the chat box 1.2 if you feel 1.2, or if you feel 1 CR, just put 1 CR in the chat box. See, understand, just again reminding you, this is, there has to be a communication between me and you. And if you go wrong, nothing wrong. No heavens are going to fall. And no one is absolute right in our profession. So don't worry about anything. If even you go wrong, no one is going to remember went wrong. So don't worry about that. But you, yes, Vidhi. What about others? Yes, yes, Raj. So market value, which is higher. Now question will come is, what is the market value of that property? When we are talking about the market value of the property, every year government publishes a ready reckoner. And in ready reckoner, they define the survey number. I will try if I can open that. You will have a survey number, and what is a rate over there? Rate from immobile property, rate for constructed property, the rates which will be given over there. And on that basis, when they say this is the survey number, on basis of that, if it's a constructed property, there will be a rate per square meter. And other thing which I want to tell you, please keep it in mind, most of you might be advocate, is technically you have to mention everything in the square meter, or otherwise it becomes an offense. Ah, name of that act I'm not able to recollect right now. It's an offense to do any transaction. How many of you know it's an offense to do in a transaction in a square feet? If yes, type yes. If you know, put no. A no. Yes. Even I was not knowing around 8 to 10 years back. I'm not able to recollect that act. So name of that act. Metrological Act. Metrological Act. Exact name I'm not able to right now recollect. Even I was not aware after that time, after 15, 20 years of experience. So don't think that you are the person who knows everything, or you became an advocate after 20 years, you know everything. Even I today find something new every day. So under that, if my client had put a hoarding everywhere at particular square feet, they are selling the flat, So they took an action, and that time some commissioner had come, and they took action against many of the real estate developers who are selling in the square feet basis. So always the transaction when you are putting, technically it has to be always in the square meter basis. So you will find all this ready reckoner, everything you will mention it is in the square meter basis. Okay. So now market value, what will happen in this kind of situation when we are talking about market value? So let me also touch about the income tax also. When this kind of transaction takes place, which I have given you the example, a flat which is there, market value is coming 1 crore 20 lakh, but transaction is being done for 1 crore rupees. So what will happen is that stamp office will collect the stamp duty on 1 crore 20 lakh. Similarly, even income tax department will consider it as sale for 1 crore 20 lakh. And what it does is that, funny part is that 20 lakh gap is a profit for the seller also and for the buyer also. So both will end up paying income tax on that difference of 20 lakh. For it will be, if it, whatever profit, suppose by selling that flat, that fellow is making a 20 lakh profit, assuming just for our hypothetical discussion, 80 lakh he brought and he's selling it for 1 crore rupees. So he's making a 20 lakh profit. And if in normal transaction, if he had to pay the income tax on 20 lakh, but in this case, what will happen is that he will have to pay income tax on 1 crore 20 lakh rupees. Assume so 40 lakh will be considered as his profit. Similarly, what will happen is that because he has got a flat, the seller, a buyer has got a flat for less than 20 lakh, for less 20 lakh rupees, even it will be considered as a 20 lakh profit. You can just cross verify this. I am not an expert on the income tax, but just cross verify this. Okay. So now when we are talking about the gift deed, now we saw, just I told you, go through this definition. Now when talking about gift deed, and we are going to see the schedule of the property. So let's go down, scroll down. I have shared it with everyone. See, this is schedule 1. So they are talking about different kind of document, acknowledgement, which we normally deal with is this article 5, is normally which we deal is agreement for sale. Then other is 25, which is conveyance. And now you are someone has asked about the gift. Just let me go fast. See, when we are talking about the gift, what it says, gift of not being settlements, because settlement, there is different this thing. Same, when this gift, same duty as is leviable on conveyance as the case may be article on the market value of the property which is subject matter of gift. What was the query here? On gift deed, I believe, no? Just sorry, I'm scrolling down. Gift deed. So when it is on gift deed, it is the same stamp duty which will be applicable as that of market value of the property. But then again, what they are given, certain exemption. If property is gifted to the family member being husband, wife, brother or sister of donor, or any lineal ascendant or descendant of the donor, then amount of the duty chargeable shall be at the rate 3% of the market value of the property which is subject matter of the gift. So if it is being given to the family member as they have defined here, then it will be 3%. But there is further provided further that if residential and agriculture property is gifted to husband, wife, son, daughter, grandson, granddaughter, wife of deceased son, amount of duty shall be chargeable will be 200 rupees. Something was going on about this that they are going to increase, but I am not aware of it has been. So there is the understand over here. Please, when you are interpreting about any provision in the law, when it is a fiscal provision, when you are reading like this financial this thing, it has to be strictly interpreted. Means when you are talking of this strictly means it will have to be strictly. You can't say this and that. If gift, what is it is saying? If it is residential and agricultural property. So only two properties they are defined. This is agricultural and residential. And it is gifted to who? Gifted to husband, wife, son, daughter, grandson, granddaughter, wife of a deceased son. So they are defined only whom it is given. So if you are strictly following within this, one is that residential, agricultural, and the relationship. Similarly, above also. So if you are strictly following within this, only then you will the stamp duty which will be attracted will be reduction in the stamp duty. Otherwise, it will be deemed as a conveyance. So another issue which is that release deed in inheritance. I'm not Reshma is there here.
Yes, sir, I am there.
Reshma, what is a release deed in inheritance? Just I'm trying to
Uh,
understand. Maybe
yeah.
some.
The property is inherited by
Hmm,
suppose two sons
okay.
from father and mother.
Hmm, right.
Then they execute the release deed in it. For that,
Okay.
the stamp duty is lesser. That's 200
Yes.
rupees. Some exemption comes.
Yeah.
So my
Yeah. Yeah.
question, I just
Ah,
want to make something just to be clear about the question, sir.
yeah.
My question is actually what in practice what we are seeing is that suppose father and son has purchased one residential flat
Hmm,
and
hmm,
subsequently the father gift is 50% share to the son.
hmm.
Actually, to my mind, it comes that it is not a gift; it is actually released by a co-owner. So, from the stamp duty perspective, in practice, we see that they label it as a gift of 50% share. So, whether it is correct, that I just wanted to verify.
Yeah. See, Reshma,
Yes.
when we are talking first, see there are basics of certain law. When we are talking about the property, the transfer of property comes into the picture. Contract Act, Transfer of Property Act. And if you are into litigation, even if you are not into litigation, it's for everyone. Huh? Just telling you everyone. Uh, Specific Relief Act. These are the acts. No, we have to read it more and more. Every time I read it, I find something new because there will be certain new problems. So now coming to your issue, why I took up this topic is that under the Transfer of Property Act, if you read, I am not recollecting, I think around section 40 or you will find it. Whenever two persons are buying the property, it is presumed that they have equal share in the property unless specifically stated therein. So, what happens in your case, which you described just now? both son has got 50% share and son has 50% share and father also 50% share. So both are co-owners. So what is happening is that he is not releasing his right. The release will come into picture normally is that if it is something jointly which has come into the favor of everyone together. Let's go take in your example after taking extending your example. Suppose the father has taken that property and thereafter he has expired. So both the parties have the right in the property. In that, when he is releasing, giving up his right, then that will be considered as a release, as a release. But this is not release; they are co-owners, so this will not consider as a release deal. Just let me, because this is a topic which has come up. Let's just check. Let's check whether have you checked whether the defined release deed in this,
So it
whereby
is not actually clear
I
in
think
the
it just
definition.
whereby person renews a claim upon other person or against any specific. No, it is defined anywhere. Just let just check. We'll check. Just a minute. No, I believe it's not defined anywhere. That is here, it is not defined, but they are made chargeable. What is this? That is to say, any instrument not being an instrument whereby person renounces claim upon other or whereby instrument not being an instrument as provided in section 24, whereby person renounces a claim upon other person or against any specified property. Yeah, that was up. I was whereby person renounces a claim upon other person or against any specified property if release deed of an ancestral property or part thereof is executed by or in favor of brother or sister or son, daughter or XYZ. I am not going to renounces the legal heir of the above without consideration in any form. Then it is, yes, that's what I was telling you just a while ago. Then it is 200 rupees. But in any other case, it will be considered as conveyance transfer. So my point which I was telling you is the same thing, because if it is something which he has got in his by way of inheritance, then he is giving up his share in the property. In that case, 200 rupees will be without, presuming it is without consideration, then 200 rupees. Otherwise, it will attract a stamp duty. Have I replied your query, or still there is something going on in your mind, Reshma?
Yeah, sir. It is only confusion here is that
Hmm.
if father and son has purchased the property, so we treat them as a co-owner, the joint owner of the property. In that case, if one person is giving his share to the other person, whether it will come under the gift or a release.
No, it will not come in the gift. Because just take an example. In how will that other person, means
Hello,
suppose father
hello,
was to, yeah,
hello.
yeah, who is that?
Yeah, I'm Pramod. May I say something?
Yeah,
Sir, this is very simple. Now, A is a father and B is a son. Now, in the lifetime of a father, he can give only give gift by his 50% share. Now, once he expires, then suppose that B son is having any other brother, he can do release date because then it becomes an ancestral property.
that's what I'm explaining. Yeah,
In
that's
the
what
very. Mm. So in the
that what I'm
father's lifetime, it is only gifted of his 50% share.
so
Can't be
Reshma.
released.
Yeah, just hold on. That's what Reshma. There are two. One 50% he is holding. He is an owner exclusively not. He is an owner of 50%. Other 40% he is an owner. So when he wants to give that 50% share, there will have to be a transfer. The transfer could be by way of gift deed, or there can be transfer deed, whatever name you call. So it is not a release deed because inherently he doesn't have any right in his 50% share. If you have anything in the mind, let me know. Okay.
No, that was the only question, sir. That whether
Okay.
it will
Okay.
be called as a gift, because generally what we say is a gifting is, suppose I am having something in my hand, I am
Huh.
giving it to the other person for no consideration. It
Right.
is a gift. But now here
Right.
it is they are the joint owners having some undivided share in the means common share in the property. In that case, whether he is releasing his 50% to the other person or whether
No.
he can give the 50%.
No.
Because
See,
the stamp duty is different for both the things,
so
both the
you show it as a
interpretations.
gift. No, you show it as a gift because I don't see it can coming under this under release this thing. So you show it as a gift. Make it a gift deed. The gift deed will reduce your stamp duty. But
Yes, sir,
always
that
remember,
is true. Yeah, that is
it
true
will
that it
reduce
will
your
reduce the stamp duty.
stamp duty. But also remember that if you are depending on which area, every area has got some other says uh, and local area tax that is also 1% and all. So you check that also while advising your client if you are not doing it regularly. So you will attract one is that maybe even stamp duty is not applicable. There will be local area tax on some area. It is a cess also 1%, and then registration charges will be there. So all those things you remember when you are advising to the client.
So one question.
Yeah.
What's the difference between a gift deed and a deed of settlement?
Settlement they are defined here. Just now went through this thing. See, it's a basically same thing. Depending upon how you are structuring your transaction and how you are putting it in the document and the way the stamp authorities will read it. There could be a settlement by which normally when we are talking about settlement means what happens is that you are giving, suppose you have 5 flat, you are giving 1 flat to one brother, 1 flat to son, 1 flat to daughter. Like that is what our normal thinking when the settlement comes or a family arrangement. Sometimes you call it family arrangement or settlement also. That is a normal which we are talking about. So normally in when it is settlement, there are composite many properties which comes into that, and in that you are giving property to XYZ. So there will be a settlement of the settlement or the family settlement or family arrangement also. So it will depend on the kind of how you are structuring the document. Now extending your thinking on that is what how you have to do the document. When you are doing this kind of document, difficulty which arises is that the title document, who is going to own the title document or who is going to keep that document. So always we are digressing from the topic little bit, but always make this family arrangement, and with that always make a further document where actual transfer is taking place. Okay, just I will
Yeah,
go ahead. Yeah.
Sir, may I
thank
add a
So
you.
point?
yeah,
Sir, this basic and the most simple
who is
difference
speaking?
between sir, my name is Raj, Advocate Amrit Raj.
Okay.
Just with your permission, may I add a point, sir?
Yeah, yeah.
Sir, in a deed of settlement, a deed of settlement can happen between anyone. However, when it comes to a deed of gift, it can happen only between blood relatives. For example, a deed of settlement can happen between a divorced husband and a wife. However, a deed of gift cannot happen post the divorce. Hence, a deed of gift can happen only between blood relatives or people related by law, for example, by marriage.
No,
However,
no,
a
no.
deed of
But
settlement can happen
where you get that gift can only be within blood relatives.
sir, gift ideally can only be between. I mean, I cannot go ahead and gift someone who's not related to me. Can
No, who
I?
told you? Who told you? Check definition of gift. It should be out of love and affection without consideration. That's what required. It is doesn't say that it has to be only between relatives. So gift can be given to anyone. You can give to a
So,
gift to a total stranger, no problem. Only what
so
you get a benefit is when it's a family and blood relation is a reduction in stamp duty. Gift deed doesn't require to be only with the blood relation. You check with the definition. I think last time we took gift, right, Rakesh? I think 2 weeks back we took that gift part.
Yeah,
I
yes.
think one article 126, sorry, section 123 or 126. I think 126 deals with that. You can check that this thing is on the this thing on the YouTube also.
okay, sir.
Uh,
I
just
will,
coming
oh,
to
yeah.
that topic. Yes, I hope every one of you are subscribed to our YouTube legal legal scholar academy. If not, kindly subscribe to that channel so that all this notification you will get as and when we upload the videos. Even this webinar's video will be uploaded. Okay. Oh, okay. I think there are a lot many, but what I will do is that I thought I can cover these things in a few minutes, but I can see that a lot of questions are there. Uh, just let me just give me a minute. Let me. Jigna is there? Anybody here whose question I have not taken? Anand, I think I have covered all the things what your questions were: sale, relinquish, deed of settlement, etc. Anyone whose question I have not taken who is here in the webinar and I have not taken the question? Okay.
Sir, may I audible? Am I
Yeah,
audible?
yeah.
Hi, sir. This is Rajini here.
Ah,
Yeah, yesterday in the group itself, I have put my query. It
ah,
is regarding the transaction
ah.
where there is a vendor, there is a purchaser, and there is a confirming party. Okay,
Okay.
the confirming
Yeah, I read
party
that
has
somewhere. Huh?
supposed, yeah,
Go
the
ahead. Huh?
confirming party supposedly entered and executed a MOU with the vendor, and therefore we have to include in the transaction for AFS. Okay.
Right.
So after AFS, at the time of conveyance, it
Hmm.
is decided that confirming party will first take the conveyance, and after his conveyance, the confirming party will be a future vendor and will transfer the title of the land to the purchaser.
Okay. Huh.
So there are two queries basically. One
Hmm.
is what will be the implications of the stamp duties for all the three transactions? That is one. And in any way, see, I don't want to do this whole transaction in one transaction because there are some tax implications.
Yeah, I got your point.
Yes,
You are saying there is a property which, in respect of which, A and B had some transaction, right?
correct.
Which was not completed. That's what you are telling? There are
Yes, yes,
two
sir.
person
Yes,
A, B, C. The transaction is not completed. The B for our discussion is a confirming party, right?
correct, correct,
Now C wants to take that property, right?
correct. Absolutely.
Right. So technically, the owner of the property is who? A, right?
Correct, correct,
So now C wants to give it, A wants to give it to C, right?
correct, correct.
Now A will not take it from C will not take directly from the B because he is aware there is a role of B, right?
Correct. Absolutely, sir.
So he will be joining as a confirming party.
Correct.
See, in such kind of transaction, what will happen is that what will happen is that who is getting the consideration which C has to pay?
Correct. One of the important
C
questions.
technically will have to pay B also and A also.
Correct, sir.
So when we are talking about a transfer transfer can take place, only owner can transfer it to the XYZ. B is not a owner. So A
Correct.
will be transferring into C and B will be joining as a confirming party. Only issue which could happen in this, maybe you will share the consideration between A and B.
Correct, sir. In fact, in the instance case, it is the case. It is the
Right.
fact.
So what is your question? So
So
what
my
is the
question
query?
is this.
One transaction, one
Yes.
stamp duty will have to be paid.
No, sir. See, with regards to A executing an AFS with a C,
Hmm.
confirming this transaction from
Hmm.
A to B and then B to C. Okay,
Hey,
there will be
huh,
AFS agreement for sale,
huh.
and later on A will be transferring it to B by their conveyance deed, and then B from a conveyance deed will transfer it to C.
See, moment you are saying A to B by conveyance, it is a separate transaction is taking place, and you
Correct,
end up paying a stamp duty on that.
correct, absolutely.
No, but why you are doing that?
So because of the tax implications on A, sir.
No, but then you are doing two separate transactions, A to B and then B to C.
Correct,
Two
correct.
stamp duty will be attracted, and just check up why you are doing it. I think later on, if required, discussed. Uh, it will be two transaction, and you will end up paying double tax, double this thing, and income tax also. I think the other implication will come of income tax also.
Sir,
Just check if
in any case, can we avoid it? Because I'm
that's
also
what
of
I'm
the
saying. If you
opinion
do the
that
transaction, show that first transaction is incomplete, and do the second transaction whereby B C is confirmed, B is confirming. In that case, there will be reduction of even tax implication, reduction of stamp duty, everything will be reduced.
okay, sir. Thank you so much.
Yeah.
Thank you. Yep.
Sorry. This new format, I want your feedback about this way, whether it's a proper or I should give a talk and then take the questions, whether how it will be. I want your feedback. Maybe you can put on this chat also, or you can put on the group also. And I will prefer you putting in another group. Rakesh, can you make the group another group and share this thing, or we'll share in the this thing. We have this who are attending this. We have the list over your participant. So 8 minutes. Just so we want. See, just there are a list we have of these participant. So we will be sharing this thing only with these people who have attended this. So I want your feedback, because what I felt is that at time I am giving a lecture and you are listening it, and I don't know how whether you are practically thinking about it. So this is how I thought I should take today's topic. What I will do is that next occasion, that is the next Friday, I will briefly go through maybe in 10 minutes I will go through the provisions of the Stamp Act and then the Registration Act. So I want your feedback whether this way it was proper or the normal otherwise which we go. I keep okay. Yeah, I want your honest feedback. Nothing, no offensive or anything like that. Because end of the day, it's like you are my customer. I have to give you what you like. It's not I may like it different way. That's what you have to think of doing in your profession. End of the day, what clients want, you have to give. You are a seller. You are having a shop. So you have to sell what a purchaser want. Maybe purchaser wants. If you are a chemist, purchaser wants a poison. Only thing is that you tell him it's a poison. Don't take it. But end of the day, you have kept it for sale in your shop. So you will have to give it. So think it. Okay, Vijaya. Yeah, I think so, because I what I gathered is that all the time which you have discussed it, and probably even I retrospectively think that maybe that uh, not necessarily I am making justice for everyone. That's what even I felt. So I thought I will take it. Yes, I will. Yes. So just Rakesh has created a group in which this group, all this judgment and all those things I will be sharing. I will be sharing. There was some
So
query
group
that,
is created. I will share a link.
yeah, put a
I have
share link
created a
on
group.
this chat
Yeah,
only. You can
yeah.
put
So that
Rakesh.
everybody can join. Yeah, yeah. Yes,
Yes,
I will
yes, yes,
put.
yes, yes, yes. Yeah. See, there was one query which was there. I will take around 10 minutes more, then we'll close it. There was one query that how is valuation of the parking is done. See, when we are talking about the valuation, I told earlier also, if we go to the this thing site of IGR, that is what is the full form of IGR? Inspector General of Revenue, you will get the ready reckoner also you will get, and you will also get the procedure how the valuation of the property is done. There are lot many factors which are covered when you are doing the valuation of the property, whether means particularly flat, when you consider about the flat, the age of the building, whether the building has a lift. So many factors they calculate. If there is a old building, then there is a factor by which the amount is reduced. If there is a lift, then the factor by which the consider means for consideration is increased. So there are various factors which are taken into consideration, including parking also, and they charge for parking also stamp duty. So all those things you will find in that will share in the group, all those things, so that you will understand how the valuation is done. But only unfortunate part of it is that that is in Marathi. It's in Marathi, but I will share with you, maybe not today, tomorrow morning certainly. So all those factors which are taken into consideration while doing the calculation of the stamp duty is there in the ready reckoner. Just give an example of your of a property. If it's a plain land, then it's not only valuation of the land, they also consider the development potential, whether TDR is permitted to be loaded or in it or not, what the FSI which is available. All those factors are also taken into the consideration. So that I will share with you that document. Means it is available. See, understand this. I am not giving you any secret of Shaolin secret that only which I am aware and you are not aware. Probably, maybe I have more experience than you, so I may have more suggestion to give you. But it is not that it is not my exclusive domain of knowledge. Fortunately, at present, at this generation, all knowledge is available. Only thing is that whether you have become capable to take that absorb that knowledge or not. That is the only difference. Because when we started practice, there was no internet had just started somewhere in at that point of time. So even I remember I had to pay 100 rupees to learn how to send email. So that was a generation. And now what I am seeing in last 6 months is totally different. Let me tell you, because I am involved a lot in the technology issues. Means so and AI and all those things. Let me tell you, it is going to change totally in next 6 months to 1 year. AI is going to make a lot of difference. I have started using lot GPT, Chat GPT. How many of you know about Chat GPT in this? Just put yes, or you can put just chat also. How have you started using in our profession? Let me tell you, it is amazing. It is, I mean to say, it is reducing your time at least by half. Only thing is that you should know what are the prompt you are giving, then how you are going to use this prompt. Somewhere I saw in the Times of India that some lawyer somewhere in US used it and you gave everything wrong. Yes, you can't rely absolutely. And you require a level of intelligence, understanding what are the kind of question you have to put, and that is how it's going to reply. If you are using paid version, it is much better than free version. So use it, and maybe after 2 months, couple of months, maybe a month after, I am going to have a webinar on that, because right now I'm developing it, how you have to put a prompt for filing of appeal, how you have to train filing of appeal, how filing of suit, all those things. I'm developing it so that you understand what are the question and what are the replies which will come, and how the preparation prior to that. It is a simple question. It is same like a cross examination. You have to be clear of what cross examination, what is the question you are asking. So that clarity you will require when you are dealing with the chat GPT. So chat GPT, it requires to be you to train understanding all those things. And let me tell you, it's amazing. And if you want to go in future, you can't ignore this. Technology has changed a lot. And I can see that in next 1 year, things are going to be drastically different than what it is today. So go with the technology. And some people say I'm old and all those things. I don't know what is the old. For me, I am don't have definition of old. I play same thing which I used to play 20 years ago, and I'm always curious about technology. So don't go with that. It's difficult. Anything, nothing else. You just put your hand. You will start learning it. Okay. So coming back to the topic which we are discussing right now. So what next? I kept the same topic on next also. I will briefly go through these provisions of the stamp duty, because what I have not discussed is I have not discussed about adjudication, because the question didn't come. Adjudication, appeal, revision, all those things I have not discussed. So I will do that on next occasion. I will just briefly overview. I will take out through the Stamp Act, and then we'll go to the Registration Act, because in Registration Act also there is a lot which we can talk, but I will prefer it after the discussion, and I think I will not adopt this format. I think this is not going to help us. Okay, then I will stop it here. Thank you, all of
So,
you.
sir, everyone is requested to use that link which I have shared so that they can join quickly to
Yeah,
the
yeah.
WhatsApp group.
See, Rakesh has shared a link of a WhatsApp link on the chat box. Kindly join this link so that I will share the judgment which I promised in the discussion today on the chat. The judgment I will be see. Let me be very clear. Those who are attending this webinar, only them. Yeah, only them. I will be sharing with them, not for everyone, because I collect it regularly. I watch Bombay High Court and Supreme Court and Marera, three website I regularly every day I see check what are the new thing. So that is a hard work of mine. So I'll be sharing with those people who are ready. I sincere in that desire to learn something. So with this, I am thankful for all of you for attending this webinar. And let's meet on next Friday and keep in touch. And I will end my webinar over here. Okay. Thank you. Bye bye. Bye. If you have still any query, put in the book chat box. Okay.